Next item on our agenda, discuss Eversource herbicide spraying and possible next steps and possible vote to authorize chairman to sign letter requesting an adjudicatory hearing. Welcome, welcome. Feel free to bring your full team up.
Who's the new guy?
However you want to shift.
Good evening, I'm Laura Kelly. I'm the director of POCCA CapeCod.org. Protect Our Cape Cod Aquifer was formed by concerned citizens, and we're specifically here tonight to discuss about herbicides being used along power lines in your town. We have a couple of great motions to bring to the table with us and a couple of new guest speakers. To just say briefly a little bit to catch us up before I hand over the mic. As we all know, perhaps June 3rd was the closing of the comment period for the YOP, the Yearly Operational Plan. Thank you for the town of Brewster for opposing document to MDAR, the Massachusetts Department of Agricultural Resources, who is in charge of overseeing Eversource's operations, and now we wait. It's been a couple of weeks. We're waiting for MDAR to, we believe, rubber stamp, approve the YOP. We're here tonight to ask when that happens, what we can do, what is our next move to protect our natural resources and thus our citizens here. So I'm going to turn this over because we have three speakers tonight that are really going to educate you guys about council, witness, and to let you know really quickly, we are working with 4 towns right now and ready to move forward with these towns. So what we ask of you tonight is historic, and we really want you to make a move. So I'm sure you know of Mr. Ben DeRider, who has joined our club here and is doing so much interaction with the liaisons of each town. And so we're going to be really putting forth some effort, even what I want to say behind the scenes of the selecting meetings, to continue to educate. POCCA is a facilitator, and so we are here to answer questions, to give you the best possible options, and to help you all through this process. So Ben is here to talk about more of that.
Thank you, Laura, and thank you, Mr. Chairman, for the opportunity to be here this evening. It's a pleasure to be back. Didn't expect to be back so soon, but it's extra exciting because Laura characterized this precisely as I would before any group. What we're talking about here tonight and asking you folks to do tonight is truly historic. No aggrieved party, and we submit to you that the citizens of the town of Brewster, through their Board of Selectmen, are an aggrieved party and therefore statutorily have a right to proceed as we're asking you to do tonight, and that is to file with the Massachusetts Pesticides Control Board for an adjudicatory hearing opposing the anticipated decision of MDAR in approving the use of herbicides and pesticides and other poisons by Eversource under our power lines. So, I'm going to be succinct because I know that you guys have a long agenda this evening. I took particular note of that. There were a number of good questions brought up by this board and prior boards to Laura and to her organization. I have answers through the good work of Laura and Dr. Jim Garb and Attorney Bruce Taub to those questions. And with those answers in hand, I also took the liberty to draft 3 motions for your consideration that essentially lay out and put into place the actions that we are requesting the town of Brewster to take through you folks. Firstly, one of the questions that came up is if the town of Brewster was to proceed to this adjudicatory hearing, who would represent the town and who would represent the multiple towns that we are asking to participate in this? We did research. Attorney Taub spoke with several firms in Boston that specialize in such matters. We learned, as we all anticipated, that the price tag attached to that is very substantial. So what POCCA and Laura are recommending to this town and to the towns of Eastham, Orleans, and Chatham, in fact, is to hire Attorney Taub to prosecute this hearing, and he has agreed in doing so to cap his fee at $36,000 from the time of filing through the time that the adjudicatory hearing decision is issued. So that was question number one. What's representation? What's it going to cost? Question number two was, what sort of expertise can we bring to bear before the Massachusetts Pesticide Control Board? And this is where the good work of Dr. Jim Garb, who's sitting behind me and can certainly answer any questions, succeeded in bringing a professor, Dr. John Stark, professor and director of the Department of Ecotoxicology at Washington State University, who has committed to coming here to Massachusetts and to testifying on behalf of the aggrieved parties in the hearing before the Massachusetts Pesticide Control Board. Dr. John Stark's short form CV was included in your packets, and suffice to say, he's an exceptional example of the type of person we were looking for in order to fight on our behalf. Next question was, how are we going to get other towns involved? And to be honest, that is why Laura and her organization reached out to me. I'm acting as a liaison between POCCA and through the various municipal bodies that we are trying to build a coalition with in order to be successful. We're engaging Orleans, Eastham, and Chatham. In fact, we were at Eastham a couple of hours ago. Without our specific motions, they invited us back to their July 5th meeting where they will take up those motions. But Laura and I, along with help from Jim and Bruce behind me, had a discussion with Eastham to bring them up to speed. So we are aiming for those four communities. And we have, through our research, developed a budget of $60,000. Hence the $15,000 figure that you see included in the packet and in the motion that I'm asking you to consider. And then finally, good question of why do we take any specific action before MDAR issues their ruling? The short answer is time, and we have very little of it. We really need commitment, specific commitment from the boards that are going to engage in this process as soon as possible, because once MDAR issues their decision, which could happen, it might have happened today, in fact, it could happen any day after the June 3rd deadline. We only have 21 days during which to file our request for the adjudicatory hearing. So those are the answers to the questions that this board raised. The motions, which I'm sure you've looked over, and I trust that you'll have plenty of questions for the experts sitting behind me and next to me. The motions really lay out the actions that we're asking this town to take, in addition to the towns of Eastham, Orleans, and Chatham. Namely, that is...
Can we let those guys speak first, and then we bring
by all
that
means.
back to the
By
table?
all
What do you
means, yeah.
think?
Sorry,
I
we
think
didn't
so.
script this. Sure.
It's improv time.
I'll step aside.
Yeah, I think we should bring Dr. Jim Garb up to chat with you guys and let you guys know more about the witness. The witness is the key player to the success of all of this. And he took months in doing research clear across the country. I'll let you give more details. And we are lucky to have our first choice. And it's the witness that's going to take it to the understanding level that we need to go in. So we're so proud to bring this to you guys today. Dr. Jim Garb.
Good evening. I'm a physician who's board certified in occupational and environmental medicine, so I have some experience with environmental issues, although this is not my particular area of expertise, the herbicides. But I have a wide network that I was able to plug into, and I essentially conducted a nationwide search of people who we were looking for someone who had primary research experience in herbicides and especially the ecotoxicology, so the effect on the environment rather than human health effects. And I identified about 40 scientists around the country and reached out to them, made contact with about 3/4 of them, but was able to eliminate most of them because they didn't really have the primary research experience. But I wound up with a list of 5 people who I thought all would be good at this particular job that we had for them. And as Laura said, my first choice was this John Stark, and I was very glad that he was willing and interested in helping us out with this. I don't know if you all had a chance to look at his bio, but he came highly recommended by 2 independent sources. People said he's great to work with, He has a bachelor's degree in forest biology, a master's in entomology, and a PhD in entomology and pesticide toxicology. He's professor and director of the ecotoxicology program at Washington State University. He's studied the effect of pesticides on various organisms and published papers on this subject. He served on the Pesticide Advisory Board for Washington State Department of Agriculture, very much akin to who we're going to be challenging in Massachusetts. He served on the Washington State Pesticide Task Force. He worked for the USDA in agricultural research. And most importantly, though, he's very sympathetic to our cause. He says Cape Cod's an important, iconic location. Everybody knows Cape Cod. He thinks this could get a lot of play in the media. And he said that, in the past, we thought that these pesticides only were harmful to plants. I mean, that's what they use them for. But he said that's not true, that they're harmful to animal life. They disrupt the whole food chain. They disrupt the whole ecosystem. So that's where he's coming from. And, I think we really got a true expert who will be an asset to this. I'd be happy to take any questions if anyone has any.
Why don't we, once you have attorney come in, and then we'll bring,
Thank you very
you can
much,
have
Jeff.
4 chairs up here, it's fine. You don't mean to make people get up and down, but,
And Attorney Bruce Taub from Orleans.
So your loss was our gain, of course. Ben has just been fantastic at this, and, it's just, here's Laura Kelly, who's 12 years pursuing this and doesn't have,
7.
oh, okay, 7. She's younger than she looks. In any event, you were by far the most receptive board we were in front of, and we really need you. Somebody's got to take the first step. The first thing Eastham said to us is, has anybody else committed? Well, anyhow, what amazes me, and I can't remember if I said this the last time I was here, but this process has been going on for 12 years at least, where the energy company, Eversource, NSTAR, its predecessor in interest, whoever it is, sends in the YOP to MDAR. And MDAR says, by statute, they send out certified letters to the town manager, to the head of the Board of Selectmen, to the Department of Public Health, and they say, anybody who has any comments, please feel free to comment. And then after you've commented, they say, well, thank you so much for being concerned citizens and telling us what you think, but no, your concerns are speculative. The Mass Department of Agricultural Resources is merely approving what the Mass Department, the Pesticide Advisory Board, a Pesticide Control Board, has determined. And the Pesticide Control Board determined it because the Mass Environmental Protection Agency determined it. And the Mass Environmental Protection Agency determined it because the EPA determined it. And we all know we can trust the EPA. And the EPA determined it because Monsanto told them this is good data. Okay, so this fella Stark is like 5-year-old studies are like a generation old already in the science of ecotoxicity, which wasn't a word as best as I know before. I don't know who gets the credit, Rachel Carson, or something like that. So we believe that the real target is the Massachusetts Pesticide Board. We believe that we're going to embarrass them by having them have to admit that they have old data, that they haven't been doing their homework. And in that sense, they can't approve these because they don't have sufficient scientific ground. That's the core of our argument. I don't know what else to say. attorneys have this experience. You get a case, you look at it, you say, oh no, there's no way we can possibly win. But I'm being paid to be a zealous advocate, so, you know, and by a month or two into your criminal case, you're thinking, I could get a not guilty here. I've got reasonable doubt. And then the jury comes back and says, it's guilty, and it's like, of course, what was I thinking? We can win this hearing. That's what I believe. And if we can't win this hearing, we can get unbelievable publicity for the protection of our environment, which is Cape Cod, and support for that. So I hope it goes forward. I mean, I feel a little embarrassed because I'm advocating for my own hiring as well. But I don't want anything more than any town council gets. And I'll be representing 4 towns. I really would like to cap it at that. I mean, we could drive the price down to $5,000 if we had a dozen towns, but the effort and the coordination with a dozen towns, we just don't want to go there. Somebody in this meeting said, I think it was Mr. Foley, but I don't know who it was the last time we were here, God forbid there would be a tragic event, and what would the consequences be on the property values and the taxes in this town? So it's a good investment.
I have a quick question for you.
Yes.
Can you tell us how important it is to have such a good witness? I know we've discussed him.
We couldn't, there hasn't been an adjudicatory hearing in at least 15 years. Why? I don't know, but nobody is an expert in adjudicatory hearings. You call these Boston firms, you talk to the managing partner, you know, it's people who are challenging state agencies. Those are the people who generally have the expertise. And the people who have the greatest expertise are the people who served in the Attorney General's office. It's like, you know, the prosecutors go on to work for the insurance companies, the Attorney General's people go on to do this kind of work. And the one adjudicatory appeal I found an appeal of actually happened in Falmouth. Did I say this the last time I was here?
I don't think so.
So there was the sighting of a waste treatment outflow of some kind, and some abutters challenged it. And they called for an adjudicatory hearing, and they were represented by a Boston firm, and blah, 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 blah. But when the appeals court was asked to rule on the Pesticide Advisory Board's decision to support the treatment plant as opposed to the abutters, they said the treatment plant did everything that DPW or DEP said you should do. And they're the experts. These citizens are merely offering speculative testimony. The expert takes us out of the realm of speculative. We're not trying to show that it causes cancer. That's not the route we want to go down. Fortunately, at the moment, we don't have that hard evidence. What consequences it's having from a health perspective, I don't believe we can credibly document. We all have our concerns. Laura can show you 300 articles that would support her argument, but I don't think one of them has the weight of what happens when you get a professor of ecotoxicology who says, I've studied it, I've researched it, this is my field, I'm as competent as anybody, I worked for the EPA. You hear that person in a different way. So
I got another question for you before you step down.
Yes.
Just to be really quick, can you bring us to the hearing itself? We have who's present, the witness.
yeah, so my image is that this is like a mini trial. It's presided over by, it goes to something called the Pesticide Advisory Panel. And they then can delegate people. And my guess is they're going to dump it right into MDAR's lap. But there'll be a dozen people sitting up there hearing testimony, run by somebody who doesn't quite have a judge's experience, but where the rules of evidence, it says in the statute, are more or less followed. You can't make the same objection and say hearsay and expect you're going to get the same reading. But it also depends who defends the state in this action, who defends the state's decision, and that could likely be the Attorney General, because that's who generally defends state agencies. How much grief we're going to get, I don't know. I did say the last time I was here that the phrase aggrieved party has special significance, and the definition of an aggrieved party is someone who doesn't have the same general interests as John Q. Public does. And one of the reasons we're going with towns rather than individuals is we want to be able to say that the aggrieved party here is the town. So that puts you in a different class altogether. Is the Board of Health, is the water supply people, and the concerns that we have about how callow they're being. I mean, I can't, because I'm involved in Pilgrim, I can't help but draw the analogy to it. You know, 20 years later, you go, you put your plant where? You know, you're turning up the temperature and killing how many fish every day? We didn't even know to ask the questions. So that's, you know, I'm excited about this. I think it's a noble pursuit, and so I like that more than representing somebody charged with OUI.
Thank you very much.
I'm going to, I have a number of questions. I'm going to open up first to the board who'd like to ask questions on any of them. Jim?
I'd like to put Ben back up here if you don't mind.
So,
Feel free to bring 4 chairs.
yeah, absolutely.
Yeah.
Love to have you all. Attorney Taub, my first questions come in your line.
Yes, sir.
From our fiduciary responsibility, as we deal with responsibility of protecting the water and of protecting the tax dollars of the town. The 60,000 grand total for any or all towns involved takes us through the pesticide board appeal and perhaps to MDAR, if I understand what you're saying correctly. At some point, there will be a judgment. Terminology may be raw. I'm assuming that the deep pockets of Eversource then say, well, they found in the town's favor, we're just going to keep appealing this thing. Dollars don't represent a problem for them. They'll just increase the rates of the people who use their product, of which we have little choice. What's the run on this, and how much time and how much money? And I'm really more concerned with dollars than I am with the time.
I think the adjudicatory hearing is realistically budgeted here. I think. I could be wrong, but I'm willing to take that risk by capping my fee at 200 hours. And that goes, I mean, any work that anybody's doing here is not being paid for. I was thinking as we came in that if this had gone to a firm and they had looked for an expert and they had put in the time that you put in with the junior associate, that would be our whole budget. Right. So in any event, to the decision. Now, once a decision is rendered, it does open the door to go to Superior Court. I can't imagine that a Superior Court hearing would be more than the $60,000. I just can't. I think it would be even less. I think it would go faster. I also think that the Superior Court hearing opens the door to a temporary restraining order, an injunction that I believe, have a high likelihood of success with. What Eversource does in the face of this, I have only the one story. You know, I represent four abutters in an action that, I'm on the air, right?
You are.
Okay, on an action in which my chances of success are thin. But I went before a judge seeking a temporary restraining order. The balance of the harms was such that the complaining abutters would be more likely permanently harmed than Eversource would be if it was precluded from spraying there. That's a long answer to your question, I realize. So the judge said, well, why shouldn't I give these four nice abutters a temporary restraining order? And the Eversource attorney instantly said, if you do that, Judge, they're all going to want restraining orders. And I said, what a great thing that'll be, you know. So they quickly said, Judge, we agree not to spray. We will make an agreement in open court with you that we won't spray these abutters, but don't give them a temporary restraining order. What's Eversource going to do if we win? How much more do they want to face? What drums? What's their strategy? How might they impact or try to impact with their lobbyists the legislation and the wording of the legislation? I just can't predict that. But I would say if it went to the next level, which is Superior Court, it couldn't cost more than $60. If it went from Superior Court to an actual appeal then, before the appeals court, I haven't done appellate work in a long time, but I would say that and you'd want an appellate attorney, you'd want somebody other than myself, somebody who specializes in appeals. I just don't, this is a pretty simple issue, $20,000, $30,000.
Total.
So, 60, 30, $150,000, worst case scenario, and who knows what other towns might join in, or agencies, or Sierra clubs, or who knows what. I mean, we got to get the ball rolling, and we're hoping to do it now, and if you endorse this, that will be a big step forward.
Where are we with the other towns? I might go to Mr. DeRuyter.
Yeah, thank you. That's a good question, Jim. So we met with Eastham earlier this evening and in order to review our progress. They haven't taken up specific motions yet because they were not included in their packet for this week. Of course, we understand that meant that they couldn't talk about this in their agenda or make specific decisions. They invited us back July 5th to do precisely that. And I wonder if I want to just, make a comment that I hope sums up some of what I know you guys are feeling. And that is, we're here talking about a very significant action that has attached to it a lot of unknowns. That's not a position that selectmen typically find themselves in when we're talking about spending dollars. So, okay, what's the proposal? Show me the contract. What are my risks? That's the maximum cost. What am I going to get when it's done? That's not what, if that is the only action that you will, the only type of action that you would take, then your only answer to this group right here tonight is no. Move along. Because that's not what this request, this action is all about. This is truly, if you don't mind me going on a little bit, I mean, this is quintessential leadership. This is a significant issue that we all know and believe that this is a significant issue. Now we have an expert telling us we're absolutely correct. It's a significant issue that, therefore, we're not going to understand exactly what the path to the final solution is. But one thing that this group knows from their long, hard work on it is that the next logical step is for municipalities to get on board and take advantage of the statute, which says you have the right to question the decision of MDAR, the Massachusetts Department of Agricultural Resources. So what we're trying to do, and what the research that these three fine folks have done is trying to do, is to answer as many of the unknowns in advance of you making a decision as we can, but it's impossible to answer them all. And the budget that we've laid out tonight carries you through the adjudicatory hearing. That we are essentially certain of. What happens beyond that? That's a very good question, and it's one that we're not going to know the answer to until we're in the hearing process. But this is where it starts. A citizen is not going to be successful bringing this action in the manner that we're asking for municipalities to do so. So that's why it's difficult to take up for consideration, and I completely understand that. Thank you.
Mike, you to comment.
Excuse me, Ben, just a quick, I know you've been to other communities or talked to other communities. Do you get the sense they're willing to participate, or are they
But could I just
dancing
take
around a
one, could I
bit,
take
waiting
one
to
piece
see?
of this because Ben's
By all
new to
means,
this?
yes.
I've
Quick
had
answer.
direct correspondence from town council in Chatham saying, we want to do this, we have $10,000. I have not so much as responded to them other than to say, you're in. Because originally, when we had talked, we had said, let's just do East New Orleans and Brewster because of the tri-town history, blah, 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 blah. But Chatham said, we want in, we've got 10,000. I haven't confirmed that in any way. And I had a significant conversation with Alan McLennan, who was the chairperson in Orleans, and who said he would serve as the liaison from Orleans Board of Selectmen to POCCA, and he said, we'll get you the money.
Okay.
That's,
Well, I
now,
think
I don't
that's-
have anything,
Jim,
that's no
what-
guarantee,
That's
but
what Jim was driving at, though. We
Right,
got a
that's
little
the
more than,
sense.
last time it was just kind of, we're still talking to those
Right.
people, but there's more of a commitment from these
Yes.
communities, which is good.
There's absolutely more of a commitment. Our job right now is within this tiny time frame that we have in which to request this hearing, is to build this coalition. And that's why we're here tonight. You guys are the first board that would take up specific action if you are to entertain our requests / recommendations tonight. And I can tell you what, just based on my limited experience, if this board is to take action, it makes our job in continuing to build this coalition far simpler, because the question we got tonight, as Laura said in Eastham, what other towns have signed on? I'll be able to say Brewster signed on, they were the first to sign on, and then we'll go get you the other 3 towns.
Jim,
Just continuation. We've been talking town dollars, 4 towns. You mentioned Sierra Club. I'll bring up Conservation Law Foundation, and there's another dozen out there. Where are we in corresponding with them and bringing them on board? They bring deep pockets. They bring people who have done a lot of this before, and they verify what a small board has shown an interest in the past.
No, it's a very good question, Jim. The short answer is that we have not engaged groups like that yet, but I believe the long answer and the more accurate answer is that this action, this is baby step number 1. When this gets through the hearing process, if we are unsuccessful and we decide to press on into the court system, we'll have garnered a great deal of significant press. I mean, I do believe that this has the opportunity to become a nationwide hotspot of communities engaging in frankly prohibiting these types of activities going forward. It's when you have the media at that point, you can engage organizations, I believe, successfully, like the ones that you just brought up. I think it would be premature at this point, to be perfectly honest. But this, Bruce is correct and Laura is correct. This, particularly with the expert that Dr. Garb brought on board, this is going to garner a great deal of attention, and it's going to help us bring more resources to bear on the issue.
Thank you.
More, if I could just add something, more than one of the experts that I spoke with said that often cases like they've seen similar cases in other areas, and often the utility is willing to back off just to avoid the negative press. You know, even though you don't win a judgment in court, you might get where you want to go just by the threat of all this negative press. And, you know, they thought it would be substantial for them, a lot of heat for the utilities.
okay. Cindy, any questions on Dave?
One question, I think, for Attorney Talbot. What is the timing likely to be if after the adjudicatory hearing and all the way to...
Here's my hope. They come down with a decision tomorrow. We somehow, in the next 21 days, find 4 towns who sign these agreements. We file the request for the adjudicatory hearing. The statute says that it will be scheduled in a reasonable time. I don't know what that is. It's certainly not going to happen in July and August.
No.
But September would be real nice, October would be fine. I'm a kind of snowbirdy guy. I'd like to get this done before November, if possible. The other thing is, we have the argument to say, this decision should be made before the spraying season, and the spraying season is in the fall. So I think we have a fair shot at having this completed. Famous last words, but I think we have a fair shot at having this completed by November 1.
Thank you.
So I just want to say briefly, if this board plans to move forward and agree to the 3 motions, I'm going to let Ben read aloud and go down this direction. It brings us to a level where we can go to the press, where you have made the first step to change history. And no pressure, but pressure's on, okay? It's up to you guys to do the right thing for everybody on Cape Cod. Be the leaders. Some towns are followers. Wellfleet, I'm not gonna say that. And some towns are leaders, and we need somebody to take the first step, and the others will follow.
I have a few more questions before we get to the idea of motions. Jim asked some of my questions already. At the last time I asked you to think about, or I said we would have to think about cost-benefit analysis, as Ben has already alluded to. What percent of the glyphosate that is glyphosate, if I pronounce it right, glyphosate, that is used in Cape Cod is represented by these sprayings?
So there's daily charts written by Eversource given to MDAR through Governor Patrick and 6 months of persistence from POCCA. It was granted to me for 2013 and 2014 every day, what they did every day, where they sprayed, which corridor they're called, what the temperature was, what the wind velocity was, and they're absolutely violating their own written regulations. Not going there. Thousands of gallons of herbicides were sprayed those 2 years. I don't know about last year. I have not got 2015 results. We had 13 towns sprayed last year, 9 towns sprayed the year before, 8 towns sprayed the year before that. So what is the percentage of glyphosate is the active ingredient in Roundup? There's 5 different herbicides that they propose to use. So it would be in those charts, and I'd be glad to give you those charts. I can't give you that answer straight up. I don't know.
I thought that your emphasis was slightly different. You were saying if you took all the whatever we call
Glyphosate.
it, that's applied in Massachusetts, and we got an N of 100, and then we asked how much of that 100 is going into the Cape, what's that number? Because aren't there bigger, better targets when you pass the vineyard and you see them spraying? What's that consequence, and what are they putting on it? I think the proper answer to that is if you win one battle, then you can win the other battles. Why?
I appreciate your point there. A figure I heard, and I can't verify because I just heard it, was that it's about 2%. About 2% of the use of glyphosate on the Cape is represented by Eversource spraying. Where other ones are, be it golf courses, though I did verify today, our golf course does not use any glyphosate. But it doesn't mean others don't. Cranberry bogs, certainly residential customer uses. We are, as you know from having been before us, we are certainly very much on your side in terms of the goal of reducing risks to our aquifer. Have we considered a town bylaw on banning the use of glyphosate in the way that you have had towns that ban the use of plastic bags? How does that go as a strategy? And have you? I'm sure I'm not the first person to think of it, and you probably have an answer for why that has or hasn't worked.
You preempted.
Wellfleet just did this, okay? Wellfleet just wrote a bylaw a month ago, so really recent, stating said chemicals, whatever their list was, and they're feeling as though they're protected. There is a Massachusetts preemption law. So as much as we want to write down here on town levels, the state's going to override it anyways. So unfortunately.
It could override it for the Eversource spraying. Does it override it for things like golf courses, private use? In other words, so that 98% that is not represented by this, do you get a good chunk of that attacked by that approach?
If you prevail on any one property, if you will, being damaged by this, then you've opened the door to banning it across the Cape. It doesn't matter who your first target is. This is a nice first target because it involves these rights of ways. It's less private ownership. The town has a significant amount of the right. The town owns a significant amount of the rights of ways that are being sprayed. But yeah, it could be another target. You wouldn't prevail if you passed an ordinance and then you go to the local store and you say you can't carry this. It just can't be done because of interstate commerce and because of who makes those decisions. It's one thing to say our town is dry, we don't permit the selling of alcohol, but to say this town doesn't permit the spraying of these toxins, you wouldn't get away with it. That's my opinion.
That sort of reversed what you said. In other words, you said we could prevail on people buying here, stores here, not to sell it.
No,
Because the same way you could say it's a dry town and we can't sell alcohol.
No, I believe that you can't prevail to get the stores not to sell it. You can prevail to say we don't give alcohol licenses. You can't say you can't bring alcohol into this town.
No, that's what I mean. So I was saying,
So-
you
so
could
you
prevail
say-
on people not to sell it.
I don't think.
You couldn't prevail on people not to be able to use it. If you're making the analogy. And I don't know whether that analogy is correct, but I'll let that one go. I would suggest that Jim's question about private funding of this process is not premature in any way. I mean, if you look at you brought up the example of Pilgrim, which is a great example. Those folks were never before us asking for money, as much as we were potentially agreed parties at risk of the same effects of any private individuals. That was privately funded, as I understand it.
I'm sorry, I misunderstood. What was privately funded?
Their advocacy was privately funded.
In opposition to?
In opposition to the Pilgrim relicensing.
I know of no private funding of any advocacy. It was conducted by the Attorney General, who's a paid staffer.
Yes. That's certainly true. The state government did, but there. I mean, the local grassroots organization worked on that.
Yeah, they didn't get funding. They just got citizen volunteers. And we know how successful they were.
Well, ultimately, there was success there. We hope in process. I would suggest, though, that it's not premature to be approaching people the same way you approach us. That this is an issue that is worth supporting. What I'm expressing to you, and I'm sure you perceive, is that the idea of us taking on a $15,000 liability, $30,000 or $40,000 liability in the long run to pursue this through is a very difficult one for us to commit to, given the uncertainty of success. And I understand that's the nature of the process. You take a risk. I'm sure we're going to get support for the first of your motions. I'll wait and see how it goes with the other motions at this point, given the amount of uncertainties that we're talking about. one other question, I'm trying to get through my list. What other towns are on the spray list in Cape Cod, other than the 4 that we're talking to?
In fact, the 4 that we're talking to tonight, not all 4 are included on the 2016 yearly operational plan. The reason that we have identified these 4 towns as the 4 we want to approach to join in the coalition at the adjudicatory hearing, to be frank, was largely born out of the tri-town relationship that already exists between Eastham, Orleans, and Brewster. And as Attorney Tobe stated, Chatham sought us out. So it certainly made it less expensive for the 3 towns involved in tri-town. You know, and I just want to, if I may, Mr. Chairman, point out one. I just want to make sure we're being very clear about how this process goes forward, and the reason we're here talking about town dollars. The reason we're talking about town dollars is because the aggrieved party in this case, we submit to you, are the citizens of the town of Brewster, and the town will be arguing the adjudicatory hearing. This organization is here to facilitate that process. We believe that it actually is going to take municipalities in order to be successful at that level. So it is the town's fight to fight. Our job is to do the homework, do the research, build the coalition, because I understand it's hard for one board of selectmen to go wrangle another board of selectmen and 2 other boards of selectmen and come together around a plan. That's the role we're playing, and that's why there's town dollars we submit to you on the table. Now, that's not to say, you're absolutely right. A private individual could come along and say, well, you 4 communities are going to file for this hearing, and I'll write you a check for that. And certainly that's work that can be done, can continue to be done. But the problem is right now, we're up against a wall, and the hearing either needs to be requested or not. And we want it to be the 4 municipalities that we've identified this evening.
I will just say, for my own personal, and then we'll get into it, we're in a process where we're transferring between town councils. We have 1 town council retiring at the end of this month, and a new town council hired as of, well, as of a later action item on tonight's agenda.
Congratulations,
Thank you. I personally would suggest that we'd want to consult with our incoming town council before we pursue this road beyond the step of requesting the adjudicatory hearing. I absolutely see the necessity of making that decision now. And I understand you don't want to wait, and you can't throw a hearing together in a matter of a couple of weeks. But I personally would like to give us we have a next meeting in 3 weeks, for us beyond the stage of committing to requesting the hearing, to give ourselves a little more time to do a little more research on it. But that's my own personal one. Of course, anyone on the board is happy to make a motion, and we will follow those motions. So I don't, unless there's any other questions from the board, I am happy to, is it Mike?
Just one quick question, and I had sent this out before. We requested a hearing with the original letter. We have to request another, which is why I said, as soon as you hear, because the board had approved it, as soon as you hear, we'll get the letter out that same day. So it's important that somebody get back to me when you hear. We'll keep an eye on it too, but just to be able to at least get that letter out requesting the hearing.
The request for the hearing in the letter was
It was
with an excess of caution, but it doesn't stand as the adequate.
That would be me.
It doesn't stand as an adequate request until after there's been
until
a
after they make the
denial.
decision,
Yes.
which we assumed, yeah, okay.
Which is the reason the
Yeah.
motion I drafted simply authorizes you to sign.
It reiterates that and does it as opposed, post-MDAR decision as opposed to the
Okay.
pre-MDAR decision. Jim?
I'm going to take motions one at a time. I move that to authorize the chair or his assigned to sign a letter requesting an adjudicatory hearing before the Mass Pesticide Board relative to the matter of the Eversource Energy 2016 yearly operational plan.
Second.
Okay. Any discussion on that motion? Okay, hearing none. All those in favor?
Aye.
Opposed? Chair votes aye. Do you want to pursue further, Jim?
Yes, sir. Motion number 2. I move to appoint Attorney Bruce Taub as special counsel representing the town on matters pertaining to the application of pesticides and/or herbicides on or about the Eversource right-of-way, and to represent the town at the adjudicatory hearing before the Massachusetts Pesticide Board.
Second.
Okay, discussion on this item. Jim?
I understand we're going through change of town council, but it is not uncommon that we hire special counsel for special situations. We've done it in my tenure on the board 6 or 8, 10 times for a variety of reasons. I have no problem with a consultation with our new, almost new, town council. We haven't signed anything yet. And I think frankly, it would be a great idea to let them know that we're in this discussion. And maybe at some point they'll say, we've got on our firm an expert who's done all of this a few times. At that point, I want to talk to them and probably have a discussion with Mr. Taub. But the likelihood is they do more run-of-the-mill attorney work for municipalities, and this sort of expertise is unusual. I would like to follow this through. While I don't like the idea of spending $15,000 or eventually $60,000, if that's what it comes to, Dr. Garb was very cautionary in saying we're not dealing with a known cancer-causing situation. There are a lot, I think Laura will agree with this, there are a lot that consider this a carcinogen. Europe will not entertain the use of, anywhere in Europe, anywhere will not allow you to use Roundup or glyphosate or any of the complementary products that go with it. They don't want to take the seed or the grains that American farmers produce there because they have been genetically engineered to accept that. This is in the system. It's what we swallow. It stays with our body. If you look at cancer rates arising, and I'm not saying that they're necessary corollary, I'm not saying they're not either. But since this was developed in 1970, there have been a lot of changes, and frankly, 5-year-old research is outdated. We'll spend a whole lot more money if we lose our water lens underneath us. We'll spend a lot more than $60,000 trying to clean it up to serve the people in the town. While I don't like spending money on this, no offense, Bruce, I don't like spending it on lawyers either. This is good money to me. This money makes sense to protect everything that we've all lived here, we've moved here to live here for. We save tens of thousands of acres of land across the Cape. I don't think any town on the Cape saves more land than Brewster. And yet we're going to go pollute it. It just doesn't make sense. Nothing about it makes sense. And if we have to fight this in court, then damn it, let's fight it.
Jim, can I ask you, in previous times where a town has, and Mike, you may have certainly have experienced this in Rhode Island, previous times when the town has appointed special counsel, they've done so with or without the consultation of present counsel?
Sometimes with and sometimes without. Sometimes there's a conflict, and so you need a special counsel. Sometimes you've got people who specialize in a certain product, and so special counsel is brought in to deal with it. Mike's been doing this a lot longer than I have, and you probably have dealt with special counsel more than once.
Three or four times with environmental cases in Middletown, with landfills and several other issues that came up.
Okay, and my question was, do you do that with or without consultation with your town council?
Well, one time we did it without, because it was an immediate situation we had to respond to, but other than that, it was just, town council, if there was background material that they had to provide to special counsel. But it was basically the town council voted and said, we're hiring this individual, and it was off and running with them. most of the time, the town attorney would say, there's no one in my office with that area of expertise. This is a specialized field. I know so-and-so. A lot of times they would help us with the recruitment also.
I will just say that I am not comfortable with this motion prior to consultation with our town council. And that said, I'm only one vote on the board. So if this motion were not to prevail, we could certainly re-entertain this motion at our next meeting. I wouldn't preclude that. I just would like to have consultation with town council prior. Is there further discussion? Yeah, Dave?
Mike, through the chair, have we consulted with our current town council about any of this process or this matter?
She was here during some of it in the past, and we had talked to her, and she said, obviously, it made sense to appoint special counsel, someone with expertise in the area.
Thank you. Thank you.
Any further discussion? All those in favor?
Aye.
Chair votes no, so that passes 3-1.
Motion 3.
Mhm.
I move to authorize the town administrator to expend from the town's legal budget an amount not to exceed $15,000 for all matters related to the adjudicatory hearing before the Massachusetts Pesticide Board.
Second.
Other discussion on this motion?
Through the chair.
Yes, Dave.
The reason I asked about timing is not for this 15,000, but for further expenditures. And what's the timing with fall town meetings so that we may actually bring it before the town as an expenditure if we're going to Superior Court?
It's a fair question.
Since it appears that the hearing will be in September, that's fine. We're in the new fiscal year. So we have we're starting from scratch with that account. If we find after the hearing we have to go to a next level, November meeting, we would certainly have a warrant article ready.
Thank you.
Fairly common part of the process.
Yeah, and the money would come out of legal budget.
We'll come out of legal budget, and then if we found we had to get to the next level, I would recommend at that time a special warrant article
Yeah.
for fall meeting in November to appropriate a larger sum.
Okay. All right. Then any other discussion on this motion? All those in favor?
Aye.
Chair votes no. I'm sorry, I should have said no, except I think I heard 3 ayes, so this will pass 3-1 also. Okay, thank you very much.
Thank you folks very
have your
much.
motions.
Thank you for all your hard work.
Will you keep
Thank
us
you.
informed of what's happening in the other towns, please?
I heard you were the liaison.
Jim is the liaison.
Yes, you are. I'm going to write to you tonight.
All
Thank you,
right.
everybody, for making history.
Thank you for
folks.
coming in.
Thank you, Doctor.
Thank